Good morning and welcome to the Migrant Center for Human Rights DreamWeek podcast series on advocating for equality and justice in immigration law and policy under the Biden administration. My name is Sarah Ramey and I am an immigration attorney and the executive director of the Migrant Center for Human Rights, where we provide free and low-cost legal services to immigrants at our country's third largest ICE detention center located in Pearsall, Texas. We present this program to you today in honor of Martin Luther King Jr.'s work and the work of other human rights defenders, both past and present. It is our hope that you will learn more about our immigration system today and be inspired to help make our country a better place for immigrants in the coming years. With your help, we can ensure that President-elect Biden upholds his commitment to us and aligns our immigration practice with our American values and the U.S. Constitution. Today, we will be discussing asylum policy. We have 4 other podcasts as part of this series that will take place this week, focusing on border policy, detention policy, interior enforcement, and affirmative benefits. Information on how to tune in to those podcasts will be provided at the end of today. We begin with discussing refugee admissions. When President Trump took office, the refugee cap was set at 110,000. By fiscal year 2021, he had lowered that to 15,000, the fewest in U.S. history since the Refugee Act of 1980 was passed. It is important to keep in mind that there are 26 million refugees in the world, according to the UNHCR, the United Nations High Commissioner for Refugees. It is also important to keep in mind that even though the cap is set at a particular figure, the number actually admitted can be significantly lower. In FY 2020, for example, there were 18,000 people allowed to be admitted, but only about 12,000 who were actually admitted into the United States. In January of this year, the Fourth Circuit upheld a district court's nationwide preliminary injunction against President Trump's executive order that instructed the federal government to settle refugees only in those jurisdictions which agreed to resettle them. The court basically found that this consent requirement from local governments is incompatible with the overall statutory scheme governing the refugee resettlement program. President-elect Biden has recognized the dire need of refugees to find safe haven and understands that the U.S. has a part to play in helping vulnerable populations. He has set the refugee cap for the first year of his administration at 125,000 and has stated that he will be increasing this over the term of his presidency. We believe that will be important to continue advocating to ensure adequate funding to support the case processing so that this cap can be met, and to ensure that no vulnerable groups are left out of priority processing. For example, in fiscal year 2020, priorities included certain religious minorities. As listeners are no doubt aware, refugees are individuals who have been determined to qualify for protection from a location outside of the United States and then are brought to the U.S. already having their legal status situated, whereas asylum seekers are individuals in the United States who are currently seeking to be recognized as refugees. The rest of our presentation today will focus on the asylum system. One of the most significant changes over the last 4 years has been the Trump administration's drastic attempt to limit and to redefine asylum law, making it more difficult for victims of crimes to gain protection in the United States. Beginning in 2018, the Attorney General, starting with Jeff Sessions, has been the most active in referring cases to himself and ruling on immigration matters than any other Attorney General in the past. One of the most harmful decisions coming out of the administration has been matter of AB. This case limited protection for victims of domestic violence. In dicta that has unfortunately still been applied in practice by immigration judges, the case also suggests that gang violence cannot be a grounds for persecution and indicates that individuals who have quote-unquote personal problems, that they may not qualify as persecutors under the Refugee Act. The decision also discusses complete helplessness as a new standard for government's ability or willingness to protect an individual. This last year, at the beginning of a rush of rulemaking, the administration issued a notice of proposed rulemaking redefining persecution and political opinion. We will discuss this rule in more detail on the next slide. Matter of LEA, another Attorney General decision, limited the ability for individuals to claim protection based on family problems and narrowed the scope of particular social group. Matter of Negussi determined that a duress exception does not apply to the material support bar, such that if a mother is forced to feed a gang member under threat that her child will be killed, would no longer be able to receive asylum in the United States. Biden has stated that he will allow for gender, gang, and political opinion cases, but he has not spoken to how he plans on doing this, whether he will be reversing the Attorney General decisions, dropping litigation on these issues, issuing new notices of proposed rulemaking, or pushing for legislative change. He's also been silent on his position with regards to family persecution, the unwilling and unable to protect standard for police protection, and the duress exception. We are calling on the administration on day one to reverse these decisions. That includes the new matter of AB decision that was recently released last week and that further narrows the scope of protection. Specifically, that decision reaffirmed that the complete helplessness standard is the same as the unwilling and unable to protect standard. However, immigration judges in practice and a simple review of the Oxford English Dictionary will understand a complete helplessness standard to be much higher than an unable or unwilling to protect standard. We are also calling on the administration within the first month to rewrite these decisions, to issue new guidance to the agencies, so that's both the Department of Justice as well as DHS, which oversees the USCIS asylum offices, to make clear that we take a favorable approach to providing protection for those who are truly in need. We also encourage the administration to look at improving our asylum laws and the interpretations, not just getting us back to ground zero where we were at the beginning of the Trump administration, but to take proactive steps to make our laws better. Unfortunately, our asylum laws are based on the refugee definition created after the Second World War and do not respond to the needs of the communities fleeing persecution today. We ask the administration, in collaboration with Congress, to look carefully at this definition and consider expanding it. One simple way that Congress can do that will have an immediately and important effect in practice is to clearly state that domestic violence can be a grounds for asylum. The Congress has done this in the past with cases of forced abortion and forced sterilization. On this slide, you will see links to the Migrant Center's public comment on persecution and political opinion, a CLE webinar with 3 immigration law experts discussing matter of AB and matter of LEA, our policy analysis piece explaining what constitutes a particular social group under asylum law, and discussing the role of family in persecution cases, as well as our podcast on material support and duress. On the next slide, we will be discussing the litigation surrounding the asylum rule. However, first, I would like to note that the PowerPoint slides will be provided on in the footer of this video, as well as on our website, and those links can be accessed by going directly to the PowerPoint. As you can see on the right-hand side of your screen, there's a very long list of things that the June 15th Notice of Proposed Rulemaking attempted to do. This rule was converted into a final rule, into regulation, and at 419 pages. This rule, fortunately, has been placed on hold. On January 8th of this year, the U.S. District Court for the Northern District of California issued a preliminary injunction. And so this rule has not gone into effect, but is still under litigation. Now, there is a second case called Pangaea Legal Services, and this case is actually a precursor to the case we just discussed. So this is referred to as Pangaea Legal Services 1, and the case we just discussed related to the June 15th rule is Pangaea Legal Services 2. This slide here discusses a particular Notice of Proposed Rulemaking that became a final rule on November 19th and then was promptly subject to nationwide temporary restraining order on that day. This rule would have expanded the bars to asylum, including for those who had past immigration entries into the U.S. for reasons completely unrelated to their claim for protection. There is another Notice of Proposed Rulemaking that became final in the last few weeks, and that is the September 23rd Notice of Proposed Rulemaking that became final on December 16th, requiring asylum applications to be filed within 15 days of the first hearing. This final rule would make it virtually impossible for individuals to submit asylum applications with the level of detail and the clarity that not only will give them their best chance in court, but will also allow immigration judges to efficiently review their case file. We have a public comment prepared with more details as to our experience working on the ground and how we believe this rule will be particularly harmful to low-income asylum seekers and those without legal representation. Fortunately, on January 14th of this year, the District Court granted a temporary restraining order and preliminary injunction halting the implementation of this final rule. Now turning to the third country transit ban. As listeners are likely aware, on July 16th, 2019, the administration issued an interim final rule. So as opposed to a Notice of Proposed Rulemaking, which is not considered to be effective law at the time, an interim final rule goes into effect immediately. And we at the Migrant Center began to, very shortly after this rule came into place, see a negative effect play out with the individuals we work with. We began to see a number of negative credible fear interviews where the asylum officer was no longer finding them eligible under the higher withholding of removal standard, which requires a greater than 50% chance of facing persecution, whereas for asylum, it's about a 10% chance. For those who are lucky enough to get through the interview process and appear before an immigration judge, judges were routinely denying asylum and granting withholding of removal. Withholding of removal is effectively an order of deportation that is temporarily withheld while the problems persist in the individual's home country. There is the right to work, however, because it is not a permanent form of protection, that individual does not have the right to family reunification. They cannot petition for their spouse or their children to come to the U.S., and they have no pathway to permanent residency or citizenship. On June 30th of last year, the District Court for the District of Columbia vacated this transit ban. And as of this date, immigration judges have begun to consider asylum cases for individuals in our courts. However, on December 17th, the administration published a final rule, which, with very minor changes, basically finalizes the interim final rule. And this rule is intended to go into effect on January 19th, tomorrow. So stay tuned for more updates this week as we expect a lot of movement to be happening on these rules and cases. Now, what are Biden's options? If there is a final rule in place, and all of these rules have been taken to court, sometimes in several cases, one of the options is to not appeal if there's a favorable decision. The other is to actively withdraw opposition to those cases moving forward, file a motion of non-opposition and/or a brief in support of the plaintiffs. If there's no final rule, the administration can withdraw that rule from further consideration and basically never finalize it by taking affirmative action to cancel the rule. The administration can also sit on the rule and not do anything. The risk here, of course, being that a future administration could pick up wherever the Trump administration left off without going through a new phase of notice and comment. And another option is to move forward with finalizing the rule, but doing so in a way to safeguard the rights of immigrants and preserve the few sections of these rules that are helpful, such as providing work permits, employment authorization documents to individuals with withholding and Convention Against Torture protection, basically allowing these individuals to work before they are issued their card, which can sometimes take about 8 months. So who has the power to do all of this? The immigration laws in our country are by and large matter for the federal government. And we will talk about the role of the states and local jurisdictions on Thursday during our Interior Enforcement podcast. But by and large, power rests with the executive. So that's going to typically be the Department of Justice. And so the role of Attorney General Merrick Garland will be incredibly important in shaping immigration law. And Congress. So the Congressional Review Act allows Congress to cancel rules that have been finalized if they've been finalized in the last 60 days. In fact, the Trump administration used this act to eliminate 14 Obama-era rules. And this is something that is under consideration. The risks being that unless explicitly stated by Congress, the agency cannot go back and then put in a more specific sort of like a more specific rule, or a rule that would be basically substantially similar. So there's been some calls as well to, or concerns on this act as a process that's not open to the public, that basically passes through and bypasses public scrutiny. But this is a tool that the administration has, and that it certainly should consider. And so individuals listening to this podcast can speak with their members of Congress and discuss with them being proactive on striking down some of these rules. Now, there are two programs abroad that bear mentioning. The Central American Minors Program, which was ended by the Trump administration, but basically it allows children who have parents legally in the United States, such as parents with temporary protected status, to apply for and gain a visa to come to the United States, bypassing the need to take a dangerous journey through Central America. Biden has said he plans to reinitiate this program, and we would certainly support that effort and encourage all of you to do so as well. It is also important to provide assistance, both financial and capacity building, to countries going through particularly difficult times, whether that's through civil unrest or natural disaster. We encourage the Congress to dedicate sufficient funding and for the administration to work with partners on the ground in disaster recovery, job creation, which will significantly undercut the power of gangs, and to most importantly, perhaps, help build up the institutions of peace and justice, establishing strong democracies and rule of law, eliminating corruption, and establishing good governance that will allow people to seek out justice in their home countries. We are also asking that the Biden administration eliminate the third country agreements signed with Guatemala, El Salvador, and Honduras. These agreements have basically made the United States party to refoulement, or forced return to situation of danger. These are agreements that say asylum seekers coming to the U.S. for protection will be forced to instead seek protection in one of these three countries. Of course, they're not going to be returned to their country. However, Guatemala, Salvador, and Honduras have very porous borders. They share borders and are small countries, all of which enable the gangs to move easily between these countries, and in fact, there's significant evidence that they have established networks throughout Central America. So, this is not a safe place of return for many of the asylum seekers coming to the United States. And at a minimum, the administration should be doing a screening of their case to make that safety determination before sending people away. Now, coming to our last topic, due process in court. This is at the foundation of much of our problems. First, the Executive Office for Immigration Review, where the Board of Immigration Appeals and the immigration courts are located, is not independent. Contrary to the checks and balances system that our democracy established between the executive, judicial, and legislative branches, the Executive Office for Immigration Review is actually hosted within the Department of Justice. And we have been calling for multiple years and have spoken with members of Congress. There is momentum on calling for Congress to make immigration courts Article I courts. Powerful actors, including the American Bar Association, the National Association of Immigration Judges, and AILA, the American Immigration Lawyers Association, have all come out strongly in favor of Article I courts. The administration has progressively attempted to take away the power and control the decisions of immigration judges. So the administration has succeeded in decertifying the ability of the National Association of Immigration Judges to engage in collective bargaining. The administration has given the Attorney General the power to allow the director, who's an administrative officer effectively, to adjudicate cases for immigration judges to bypass the appeal process and refer cases directly to the Department of Justice administration. There have been problems with the hiring of judges. To some degree, this predates the Trump administration, but the Trump administration has engaged in political questioning during interviews and other actions that have raised concern. For example, promoting immigration judges who have very negative records to positions of power within the Board of Immigration Appeals. But even before the Trump administration, there has been a tendency to hire DHS prosecutors as judges. There are less private practitioners and nonprofit attorneys that enter the bar. And we are asking that the immigration court system do a complete review of the recruitment process to ensure that there's a diverse bench. That the hiring process, the review process, and the termination procedures are all done in a neutral and fair manner. We're calling for the elimination of case completion quotas, where judges are required to complete 700 cases a year, regardless of how long those individual cases need to be worked on. This pressures judges to review evidence too quickly, to cut testimony short, and to otherwise feel rushed and stressed in their jobs. On November 27th, there was issued a notice of proposed rulemaking. You can listen to our podcast or read our public comment for more, but basically that limits the ability of individuals to file motions to reopen and reconsider and get stays of removal. Ironically, even though at the end of fiscal year 2020, we had over 1,200,000 cases pending in immigration court, the administration has decided to recalendar all the cases that have been administratively closed. That's about 350,000 cases. These are cases where immigration judges and attorneys, both for the respondent and for DHS, have determined that are not priorities. And so as administrative closure is something that has been limited directly by the Attorney General in matter of Castro Tum, and that has been limited as well as briefing time in a notice of proposed rulemaking issued on August 25th. The administration has also cracked down on termination, continuances, use of status dockets, and other calendaring tools. On November 27th, for example, the administration heightened the good cause standard. This proposed rule is currently under consideration, and we are hoping it does not become final. It is important for judges to have the discretion to respond to the facts in the situation that confront them. On January 7th, EOIR issued guidance stating that even though this rule is not final and is not the law, that judges can use this rule as helpful information. And that's a concerning policy guidance that we would ask on day one that Attorney General Garland scrap. The Transactional Records Access Clearinghouse, or TRAC, which gets data directly from the court, reported last summer that they've noticed applications missing from the data provided from one reporting period to the next, and other issues with data. This is really important to fix as soon as possible, because without having accurate data, it's difficult for accurate policies and funding to be directed to ensure that justice is guaranteed in our system. The administration has also worked to increase filing fees. For example, in the Notice of Proposed Rulemaking February 27th, the fee for an appeal increased from $110 to $975. This is not currently being implemented in practice, but we do believe this is a potentially incredibly harmful change that would exclude people from the ability to correct errors committed by immigration judges. There is a fee waiver process, but there's no guarantee that the Board of Immigration Appeals will grant discretion favorably on an application for a fee waiver. The program for case management. This was a program started in 2016. It had almost 100% success rate at assisting individuals in attending their court hearings, but nevertheless was terminated by President Trump. This program basically would assign a caseworker to an immigrant to assist them in knowing when their court hearing is, how to get to court, and other basic matters. And we definitely would like the new administration to reinstitute this program as quickly as possible. In addition to improving the overall language and tone of the government's relationship with immigrants, we've, in many conversations with folks in the community, understand that immigrants have stopped going to court as frequently as before out of fear that they would basically be deported, that they didn't really have a chance under the current system. And in fact, we have seen denial rates go up under the current administration for many reasons, including many of those that we've discussed about today. We are calling on for expanded representation, especially for low-income immigrants, expanding the legal orientation program that provides basic know your rights information in detention centers, to reinstitute the friend of the court policy that was basically canceled in November of 2019. This is for attorneys and non-attorneys who have information about a case that would be helpful to a judge to appear briefly before that judge to provide that information. Of course, this should be done with the knowledge and consent of the immigrant, and the judge should provide an opportunity for the immigrant to add anything that they would like to. But this is very helpful to immigrants who often do not understand the complexities of our legal system in enough detail to effectively explain matters to the judge with the same efficiency that an advocate can. The other issue that has been pervasive during the Trump administration is the tone indicating that attorneys for respondents are simply out to make money and to skirt the law. However, attorneys are licensed with ethical duties, including candor to the tribunal, and the sort of hostility that's come out of the administration has not been in any way helpful. So for example, there was a case that worked its way up to the Supreme Court where an individual was convicted of a federal felony for encouraging or inducing an alien to come to, enter, or reside in the United States. There's concern that this is going to be applied to immigration attorneys who are simply trying to do their best to assist their clients. So that's an issue to stay tuned for. With that, we conclude our podcast this morning. Thank you for tuning in. Please join us for our following podcast this week, and feel free to reach out to us at our email admin@migrantcenter.org to sign up for our newsletter. Feel free to check us out on our website or on Facebook for more news and analysis, job and volunteer postings, and to learn more about our work. Thank you very much for tuning in today, and enjoy the rest of your day.